On the 7th of July 2014, at the Palais des Nations in Geneva, UNCTAD hosted an ad hoc expert meeting entitled The Role of Competition Law and Policy in Fostering Sustainable Development and Trade through the Enhancement of Domestic and International Competitiveness of Developing Countries. In his opening address, the chair of the meeting and president of the Competition Authority of Malaysia, Mr. Sothiratchagan, set the context for the meeting, reminding that UNCTAD, as the focal point for competition issues within the UN system, maintains close linkages with the existing networks of competition authorities and with other organisations interested in competition issues. Mr. John Fingleton, former Chief Executive of the Competition Authority of the UK, made an introductory speech in which he addressed three questions. Firstly, whether competition policy should address inclusive growth. Secondly, what competition policy has to say about inclusive growth. And thirdly, how competition policy can be relevant to the inclusive growth agenda. Professor Alberto Heimle, chair of the WP2 of the OECD Competition Committee, argued that governments play a significant role in determining how markets function and use a variety of policies for this purpose, including economic regulation, trade policy, IP rights protection, and antitrust. Some of these policies, in principle, promote competition directly, but sometimes are too intrusive, while others pursue other general interest objectives, and in doing so restrict competition, sometimes beyond what is strictly necessary. The session panel was composed of Mr. Giovanni Napolitano from the World Intellectual Property Organization, Mr. John Davies from the Organization for Economic Cooperation and Development, Mr. Hassan Qaqaya from the United Nations Conference on Trade and Development, and Mr. Robert Anderson from the World Trade Organization. Mr. Napolitano gave a presentation on IP rights, innovation, competition and growth. His main conclusions were that there is a need to balance IP rights protection and competition, that competition and IP agencies must talk to each other and cooperate, and that competition enforcement has a role in controlling IP rights misuse and in promoting growth. Mr. John Davies presented on competitive neutrality in development. Most policy communities are mainly concerned with foreign SOEs as investors in cross-border investments because of the unfair advantages they can have, but the competition community focus is usually on inefficiencies and distortions in national markets, and in this sense they advocate policies to promote competition in markets with SOE involvement. Mr. Davies stated that the OECD tries to bring competition, corporate governance and investment communities together, and there are publications that provide evidence on the relationship between competition and productivity growth. Mr. Hassan Qaqaya gave a presentation on competition and resource-based development, particularly with regard to extractive industries-based development. This sector is very important for a large number of developing countries, and competition policy can do a lot to help make the most of it for sustainable inclusive growth, avoiding the so-called resource curse. However, competition policy cannot achieve this independently. A comprehensive approach and appropriate policy mix is necessary. Mr. Robert Anderson referred to the complementarities and interface between trade and competition policies. Effective national competition policies are important to the success of multilateral trading systems, including its contribution to development. This is because of 1. The importance of competition policy in deterring international cartels. 2. The importance of pro-competitive structural reforms in enabling businesses in developing and transition economies to take advantage of market access opportunities created by trade agreements. And 3. The importance of competition rules as an adjunct to liberalised government procurement regimes. Thus, the success of the international trading system depends to an important degree on the existence of effective national competition policies. Professor Eleanor Fox from the New York University School of Law provided some comments on the presentations by the panelists. She stated that there may be some underlying disagreements regarding what she called the inequality challenge and the governance challenge. The inequality challenge is concerned with the top few getting the majority of benefits, and the risk is that competition law enforcement plays into the hands of the powerful. The governance challenge has to do with the non-existent global governance structure, which most people oppose. Professor Fox stated that we should ask ourselves how our decisions impact on developing countries and on the poor, the least connected and the least powerful in developing countries. Asking these kind of questions would open up our minds to sustainable development issues. Mr. Koyochi Adachi from UNCTAD's IP unit referred to UNCTAD's mandate on the development dimension of IP rights. while recognising that IP protection is essential to recoup R&D investments. He said that developing countries should make use of the exceptions, transition periods, and flexibilities available to them in multilateral agreements dealing with IP rights protections. He explained the case of the production of generic medicines in developing countries, in particular, antiretroviral medicines to treat HIV/AIDS. The panel discussion was followed by interventions from the floor. One delegate spoke of the problem of corruption, particularly in resource-rich countries, while another asked about the right balance between IP rights protection and competition. Another delegate argued that developing countries face huge challenges regarding inclusiveness, inequality and poverty, and that there is a need to find evidence on how competition policies contribute to resolving these issues. The second part of the meeting began with the introductory remarks of Professor Fox, who referred to the issue of inequality as the elephant on the table, which everybody could see but nobody will talk about. In particular, antitrust and trade policy areas do not get to talk to each other meaningfully and surely do not talk about inequality. She highlighted how the perceived trade-off between inequality and growth have been reversed. Professor Fox said that competition law could protect against anti-competitive exclusion and monopoly, but that there were other forms of positive action that could be taken by competition authorities, such as taking into account public interest criteria in merger control decisions. Regarding IP rights protection, Professor Fox regretted that developed countries are including overly protective provisions in trade agreements. Competitive neutrality is symbiotic with competition and sympathetic to developing countries' needs for growth and development. The worst competition constraints are often by governments and their cronies and often involve corruption. Professor Fox called to set inclusive growth and development, and not just growth and development, as the objective of public policies that should talk to each other across all issues. The panellists for this session were Ms. Anna Müeller from the WTO, Mr. Richard Bolwijn from UNCTAD, Mr. John Davies from the OECD, and Mr. Nuno Pires de Carvalho from WIPO. These included that policymakers should focus on easy-to-implement, effective, and economically sound approaches to competition, which may be found by sharing best practices, and that policy needs to focus on poorer citizens as producers, not only as consumers, so as to reduce the costs of doing business and preserve export interests of developing countries' producers in the global value chains. Mr. Richard Bolwijn examined the role of competition policy in global value chains. He highlighted the findings of UNCTAD's World Investment Report of 2013, which analysed the participation of developing countries in global value chains and the value they add to them. These developing countries that set participation in global value chains as a main goal should give priority to anti-competitive vertical practices in the enforcement of competition law, followed by collusive practices, and finally, abuses of dominant position and anti-competitive mergers. He stated that more international cooperation will also be needed. Mr. John Davies recognised that competition authorities are linking up more and more, although there is a great concentration in cooperation, and cooperation in cases is still rare. Enhanced cooperation will be needed as globalisation of business develops. The OECD Competition Committee is preparing a revision of the 1995 Recommendation on International Cooperation in Competition Enforcement, which will not be revolutionary but rather an update. This update will seek to improve the ability of agencies to exchange confidential information, including the enhancement of security standards, as well as to promote the use of waivers. Mr. Nuno Pires de Carvalho discussed the relationship between IP rights protection and competition in WIPO-administered treaties. He identified 3 levels to the interface between IP rights and competition: IP rights in the wrong dosage, i.e. too strong or too weak, and anti-competitive abuses and essential facilities. He concluded that WIPO-administered treaties are ambiguous on the interface between IP and competition. Further, WIPO member states are not foreseeing harmonisation, instead focusing on promoting better understanding of the issues, facilitating the sharing of experiences, and considering the promotion of pro-competitive IP licensing practices. Professor Heimle referred to the impact of the fight against international cartels that provide industrial inputs within developing countries, and of the importance of cooperation in merger control, recalling that this was at the origins of the International Competition Network in 2001. During interventions from the floor, many delegates reflected on the role of SOEs in developing countries. Some insisted on the need to take into account the historical background of economies and of the important role that SOEs can still play in improving the economic capacity of developing countries. It was stated that this should not be incompatible with introducing measures to level the playing field between SOEs and private companies. Professor Fox suggested that UNCTAD has an important and interesting role to play in strengthening the voices of developing countries vis-à-vis that of developed countries.